The next case to come before the court is State of Ohio v. Meagan, Nesbitt. Thank you.
Would you be nice not to stop that thing?
Oh. It's like saloon doors.
That's what we always say. I feel like that's not quite the right image that we're looking for. You will have up to 15 minutes to present your argument. The argument is being recorded, so please stay behind the podium, keep your voice up, introduce yourself. You should not use the names of children or minors or victims during your argument, should that be relevant to you. You can refer to them by initials or generic terms. We have read your brief and we are ready to proceed.
Thank you, Your Honor. Obviously, since the state waived their oral argument, I won't reserve any time. Please the court, Darren Mead, 0063660 on behalf of the defendant appellant, Meagan Nesbitt. As the state has conceded error on the third of my three assignments of error regarding the sentencing and the issue of merger, unless the court happens to have explicit questions about that, I won't address that in my argument. The two assignments of error brought here are, first, that the court committed error in terms of permitting testimony regarding the HGN test. Specifically, the court found that due to lack of substantial compliance with NHTSA standards, that there was only 3 out of 6 clues found as opposed to 4 out of 6 claimed by the arresting officer. Furthermore, there was an issue at trial where the officer testified that the appearance of horizontal gaze nystagmus was indicative of, and I quote, alcohol intoxication based on her experience. Now, this was not testimony in compliance with the NHTSA standards, talking about 4 out of 6 clues, equating a 77% chance the person would be at or above 0.08, but merely to the jury that the presence of HGN was indicative of, again, alcohol intoxication. Your Honor, Justice, I would cite, as I did in my brief, this court's decision in the Hanover case from 2007, case like 2007, Ohio 2561, where the court had indicated this was not an issue, where the trial court said that the state could and did present testimony of 3 out of 6 clues being present, rather than suppressing the test altogether, and further led to the testimony about it being indicative of alcohol intoxication. In Hanover, this court found that the failure to do in substantial compliance, one phase of the test, specifically it was the presence of nystagmus prior to a 45-degree angle, rendered the entire test inadmissible. Now, the state has tried to claim, well, there's no real testimony about what about distinct nystagmus at maximum deviation or equal tracking, whether or not there was signs there. But that's ignoring the actual decision from Hanneman, where Hanneman did not, the state tries to say, well, there wasn't a discussion in the decision about it, but that's kind of the point. This court found, citing paragraph 18 of Hanneman, stated specifically that the trial court, because the trooper in that case did not perform the third part of the HGN in substantial compliance, that the test itself and testimony thereof was inadmissible. I would note that even the dissent from then Justice Slavey noted that that this issue was about whether or not further the majority concludes that since the defense shoulders were not squaring the officers, he would not have gauged a 45-degree angle. So the entire issue there was on one of the 3 parts of the HGN test. And again, this court has held that fair to do one of those 3 portions, if you will, in substantial compliance renders testimony about the HGN inadmissible. I think that that's particularly applicable in this case where, again, there was testimony which goes far beyond the testimony permitted by cases such as State versus Schmidt about that being indicative of alcohol intoxication. Again, that's not what what HGN and the other field sobriety tests are necessarily indicative of, and also the testimony that any amount of HGN from officers, according to the officer, was indicative of alcohol intoxication. Now, I understand my assignment there goes to primarily the trial court's erroneous admission of that testimony, but I would say that resulting testimony by the officer goes to the issue of this being reversible error versus harmless error. I would note that I believe the state tried to frame this rather, in their brief as being a plain error standard. I respectfully disagree with the state on that point. The defense trial counsel had filed a motion to suppress the HGN, argued against the HGN, objected to the HGN, filed a motion against it. This is anything but plain error, that as the objection was raised, and again, a motion to suppress it and being overruled is about as far from non-objected to plain error standard as one can get. So when looking at reversible error as opposed to plain error standard, when we have a case where the evidence of impairment was, and I'll get to this a bit in the suppression issue, the state again, as the government frequently does, portrays the evidence in this case as overwhelming, and therefore this court should find that this was harmless error, if anything, is just not in comportment with the facts of the case. Even the trial court during the suppression hearing noted that on the video, the evidence of impaired driving or driving over the lane was not particularly visible on the video. And therefore, it wouldn't have been to the jury. There was evidence, of course, that she had rolled through a stop sign, grounds for a stop certainly.
Was it a stop sign or a traffic light? I was confused over that.
I'm not sure.
Well, I said a record, obviously, I just was wondering.
I'm not sure, Your Honor. Either way, I mean, it would be the same violation of law and grounds for a stop, certainly.
Yeah, there's a little difference though between a rolling stop and a stop sign as well, as opposed to running through.
True enough. I believe it was a stop sign, but I could be correct.
I just can't remember right now. I don't mean to.
Same here. So, there was, the odor of alcohol was claimed to be light and then moderate when Ms. Nesbitt got out of the car. She was coming from work as a bartender, which would actually explain the odor of alcohol, which she said was spilled on her. Again, I understand that as the trier of fact, they have the ultimate interpretation of what's correct and what's not, but we're not talking about overwhelming evidence. She did well on field sobriety tests performed at the station. There was even the trial court, again, in its suppression ruling, found several of the evidence factors to be not applicable here. And some of those, as I'll get to in a moment, are arguably weren't applicable either. At the end of the day, what I submit to this court is on a case where there is not overwhelming evidence, in analyzing whether this was harmless error or not. First off, it's a reversible error standard, not a plain error standard, as noted. Pursuant to this court's decision, even with the dissent in Hanover, the HGN should have been excluded. The fact that the officer testified that HGN period is indicative of alcohol intoxication, and the lack of overwhelming evidence demonstrates that this was in fact reversible error that the court committed in admitting that testimony.
Counsel,
Yes, sure.
I know you got to get into your suppression issue, but real quick,
Sure.
in regard to the plain error versus, objection preserved and so forth. Whenever the officer testified that any indication of nystagmus indicates alcohol intoxication, Was there an objection at that point?
There was, I don't think there was, Your Honor, but again, that gets back to what I'd said earlier, that the issue was preserved in terms of this not being plain error by virtue of the motion to suppress and hearing thereon. In terms of that testimony, I think that goes again to the issue of whether this is reversible error versus harmless error. And I'm not sure an objection there, it would have been better and cleaner if trial counsel had made that objection, but again, that goes to the weight of harmless error versus reversible error. Irregardless is not a word, I don't remember that word. Regardless of whether or not trial counsel had raised a timely objection, if that makes sense.
Well, I guess the reason why I'm asking is because in regard to trying to determine if it's plain or not error, as a review, what I'm wondering is whether you had filed a suppression motion or anything, it would have been improper, would it not, for an officer to say, let's say that the HGM was conducted in strict compliance. The officer still can't say that it's demonstrative or evidence of alcohol intoxication.
I would concur, Your Honor. And again, I would have preferred trial counsel, very skilled though, and fought like a tiger here, would have raised that objection. But again, she preserved the issue from non-plain error review by virtue of the motion to suppress and argue there. Does that answer Your Honor's question?
Yes, I understand where you're coming from.
Okay, thank you. With that, unless there are other questions, I would want to move in my time left for the suppression issue. Now, this goes to the age-old question of deference to the trial court on review of the facts as opposed to de novo review of the law. However, and here is the key, case law is clear that to do so, for the court to grant that type of deference, there has to be competent and credible evidence for this court to rely on, or should I say, to give that deference to the trial court. The trial court still has to show that there was competent and credible evidence that they relied on in making those factual determinations. And this court does have authority to say there was not competent and credible evidence in making those factual determinations and reverse them, notwithstanding the normal deference granted to the trial court's interpretation of the facts. Now, as I note in my brief, there were several issues here. Perhaps one of the biggest and frankly most concerning was the trial court. I'll give great points for honesty, that the court stated outright on record that the court's policy, the trial court used the word policy, was that if the video evidence did not explicitly disprove the sworn testimony of an officer in a case, not just in this case, but any case, then the court's policy is to adopt the officer's testimony. And that was brought up in this case because, again, the trial court readily acknowledged that issues about whether or not a fog line was crossed or a curb hit was not particularly discernible from the video, even though the officer testified that her owl-like vision, night vision, was able to see what the camera couldn't. And that there, the court further inordinately deferred to the officer by accepting her claim that she could readily distinguish between the odor of alcohol that a suspect had consumed versus alcohol spilled on a person. That is truly a unique party trick, I'll say. She claimed it was by experience, training and experience. And I would just note that I'm not sure if this court has ever heard of an OPATA class or any other NHTSA training to try to distinguish, but although they perform field sobriety tests, of course, on people at different levels of intoxication who volunteers, I once did, to consume various levels of alcohol. In terms of bringing that distinction, that's certainly new, and in fact, upon cross-examination of pages 84 and 85 of the transcript, the officer conceded essentially that, well, okay, her training at least really didn't cover that. And she just knew it from experience, but could not articulate how. And perhaps what I was telling is at no point anywhere, suppression hearing, ALS hearing, trial, could the officer testify to being able to smell the odor of alcohol coming from Miss Nesbitt's breath as opposed to off her clothing, off her person. And nevertheless, the trial court didn't rely on competent, credible evidence, but this. Several of the factors that the court cited in Evans are not indicative of impairment according to the NHTSA manual. Bloodshot, glassy eyes is not considered and hasn't been factored as one for a couple issues, at least not the last one nor the current, to be indicative of impairment should not be considered as probable cause per the manual. And that's been held, as I cited in my brief, by the 6th District, just for example, in the case of State v. Dye. And while, yes, the appellant did miss a letter in an alphabet test and missed a couple numbers, I believe, counting them backwards, she conversely had no problems exiting her vehicle, walking the scene, and even at one point there was some confusion over the test, and she was able to walk backwards.
Counsel, I'm going to have to ask you to wrap up because your time is up.
Very briefly, Your Honor, I'll take the last 30 seconds just to simply note that the deference to the trial court in interpreting the facts is understood, but again, I submit on those bases there was not competent or credible evidence for this court to grant that kind of deference, especially when the court grants a blanket policy of adopting an officer's testimony unless explicitly disproven by video. And I think I've explained the first issue about HGN and why it's reversible error, especially in a case where the whole issue is whether or not the Ms. Nesbitt was intoxicated, and the testimony led to exactly that result, and that couldn't have helped but influence the jury considerably. Thank you.
Thank you, counsel. The court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail a copy of the decision to you on the day it's released, and it will also be posted on the Ohio Supreme Court website. And the court is now adjourned.